York, and it's my pleasure to moderate this program. We've got an exceptional panel. The topic, hold on a second, the topic is complying with CFIUS and other inbound and outbound national security regimes in technology investments, dealing with foreign direct investment. Over the last number of years, there's a lot of changes. A number of countries have had restrictions on inbound investment for years, as highlighted by whatever CFIUS, which everyone here I'm sure is familiar with, and it usually dealt with military weapons, weaponry or military use. Other countries had similar regimes. And then over the last decade, those restrictions have expanded to technological advances in industries, particularly China's technological and military growth and competitiveness with the West. There have been outbound restrictions on doing business with certain persons and entities, as we all know, and they're unfriendly to the governing jurisdiction, particularly related to military, weaponry, anti-money laundering, criminal activity, but not as much with technology. And recently, with a competitive threat from China, there has been discussion on outbound investment restrictions and some action on that. And we're going to review this, these issues over 5 countries / regions. They are, this is not going to be an in-depth primer. It's going to be an overview because we have a lot of countries to cover, and unless you want to stay here for the rest of the day, we cannot get into details of every one of them, but we're glad to answer questions on that as we go forward. There are excellent materials in your app. You can see the materials that go into more detail. Just a housekeeping matter, we've been asked to promote ABA books. Each program is a book. And our programs are asked to promote the International Practitioners Desk Book Series, International Litigation Strategies and Practice, 3rd edition, which is something, should be something in your bag. You can order it at the registration. You can scan the code up there. If you're interested in buying it, the authors are Ethan Berghoff and Theodore Edelman. I understand it's an exceptionally good book, and encourage all of you to buy that. So I'd like to introduce our exceptional panel. And to my immediate left is Scott Jansen. Scott currently serves as counsel at Baker & Hostetler in its Washington, D.C. office. He focuses on CFIUS, U.S. export controls, and sanctions regulatory matters. To his left is Ji Jung. She's the former senior counsel of General Motors International in Seoul. She's currently an independent consultant to a Korean automotive entity. And at GM, she led negotiations for vehicle supply and technology agreements with Uzbekistan, and she also managed transaction disputes with Japan and Southeast Asia. And to her left is Jung-Chil Lee, JC. JC is a foreign attorney at Kim & Chang here in Seoul. His practice covers a broad range of legal matters, including M&A, venture capital, private equity, foreign direct investment, other corporate transactions, and he has advised a number of multinational corporations on cross-border investments. And to his left is Lori Ann Grillier. Lori Ann is special counsel at Covington & Burling in its Seoul office. She assists global companies, especially Asian multinationals, navigating the competitive law aspects of their activities in Europe. She advises companies on high-risk, high-stake European competition issues, and has gotten involved in the structuring and licensing and commercial arrangements and other antitrust issues. And part of her practice consists of advising companies on foreign direct investment. And then, last but not least, at the very far left is Rose Chen. Rose is the head of law, intellectual property, and compliance of Covestro Taiwan, an affiliate of Covestro AG, which is based in Germany. She oversees the legal and regulatory issues relating to Covestro's business and production operations in Taiwan, ranging from import-export regulations to environmental law, and she also closely works with the global legal team on cross-border M&A. So with that, we will dive right into it, and I'd like to start out by asking the panelists to please give a brief description of your country's, or Europe's in Laura's case, inbound regulation regime. So I'll start with Scott.
Thank you, Paul. I'm glad to be here. In the United States, foreign direct investment restrictions are managed through a program called CFIUS, or the Committee on Foreign Investment in the United States. CFIUS is a executive branch agency which is comprised of 7 statutory agencies. And the chair of the committee is the Department of Treasury. The top 4 agencies that have the most cases for review are the Department of Defense, where I worked prior to joining Baker and Hostetler. And when I worked in the CFIUS office, there's the Department of Defense, Department of Homeland Security, Department of Justice, and most recently, last few years, the Department of Energy has had a lot of cases where they've had primary oversight over. CFIUS has been around for about 50 years, and in the last 5 years ago, that Congress passed a bill called FIRMA, or the Foreign Investment Risk Review Modernization Act, which expanded CFIUS's jurisdiction pretty expansively, and it's still, even though it's 5 years old, it's still being implemented. And so we'll go into more detail about what the jurisdictional hitch is, or the jurisdictional requirements for the U.S. government to intervene in foreign investment in the United States, and we'll also discuss later about how the U.S. government does its evaluation on national security grounds. That's a high-level overview of the Committee on Foreign Investment in the United States.
And Laurie, would you give us an overview of the European regime? And I know that's a broad task, but a broad ask, but if you could appreciate it.
Sure. So for those of you who are familiar with the way merger control works in Europe, FDI screening works a bit differently in the sense that there is no central European-wide system to screen foreign direct investment into Europe. Instead, it is up to each and every member state of the European Union to decide whether and how to screen foreign direct investment. So right now we have 20 countries out of 27 that have regimes to screen FDI, and the 7 remaining member states that are in the process of enacting legislation to screen those investments. While a number of these regimes have similar characteristics, there are also big differences between them, and those differences can have meaningful implications for transactions that can involve several member states, not the least when it comes to review timelines. There is also a lot of differences and gaps in terms of competence and experience in dealing with foreign direct investment, because most of the review right now concentrates in 5 countries. So France, Germany, Austria, Italy, and Spain. Although there is no European-wide control system, there is some mechanism of coordination among the various countries that has been created through a regulation called the FDI Screening Regulation. And what that regulation does is requiring member states to notify each other when they are screening FDI, so that the other countries can either ask questions, provide comments, and the European Commission can also provide opinions. Those are non-binding, but bear some influence. And lastly, I guess everyone has heard about Brexit. So the UK has its own FDI screening regime that is completely out of the cooperation system created by the FDI screening regulation. And the UK is a very active jurisdiction when it comes to reviewing foreign direct investment in its country.
Thank you, Lori. Now I'm going to turn to Ji, who's going to talk a little bit about Japan's regime. Ji?
Yes. So in Japan, foreign direct investments are largely regulated by the law called Foreign Exchange and Foreign Trade Act, in short FEFTA. And Japan's joined the recent global trend to be more protectionist, more nationalistic when it comes to regulating foreign direct investment by making the regulations wider, the scope broader, and investments into Japan are divided, they're regulated first, the inward direct investments and specified acquisitions, and both are regulated through a national security lens. So usually, if there's an acquisition of 10% or more of the voting rights of a company, that would have been the trigger for a screening by the Ministry of Finance and other related ministries. But now recent amendments has made the threshold very low. Even a 1% acquisition or more of voting rights in a company would trigger a pre-filing notification and a post-transaction filing. So that's Japan's regime in a nutshell.
And JC, you want to talk about Korea's regime?
Sure. So Korea's inbound regulation can be classified into two broad buckets. The first is filings under the Foreign Investment Promotions Act, and the second will be filings under the Industrial Technology Protection Act. The Foreign Investment Promotions Act, or FIPA as we call it, is triggered if there are any certain foreign transactions that raise national security concerns. And if those foreign transactions are subject to FIPA review, then it goes through a process we call security review process, which is very similar to CFIUS. So the FIPA review process has been around for a long time, but it hasn't actually been revamped last year, August 2022, where the Ministry of Transport, Industry and Energy, MOTI as we call it, has expanded the scope of its security review. So so it's becoming more of a stricter review process, similar to the CFIUS process under FIRMA in the US. Now, in terms of the ITA filing, it's triggered when a foreigner acquires control of a domestic company that has what's called national core technology. And there's a broad category, there's specific categories of what constitutes as national core technology, but in case of any foreign investments into the Korean companies that possess NCT, as we call it, that would trigger the ITA filing. Those two filings are different mainly in two ways. Number one is the filer, the party that has the obligation to file is different. Under the ITA filing, it will be the target company that possesses the national core technology that has to file, whereas under the FIPA filing, it will be the foreign investor that needs to file. The second key difference is that the ITA filing will be triggered only if the target company possesses what constitutes as national core technology, whereas under the FIPA filing, it could still be triggered even if the target company does not hold national core technology. For example, if it's a producer of defense materials or it has other types of strategic goods or technologies, they would still be triggered. So that's the Korean inbound regulation in a nutshell.
And Rose, would you talk a little bit about Taiwan?
Thank you, Paul, and my fellow panelists. My segment today does not represent the position of Covestro. That being said, guten Morgen, everyone. For Taiwan, the overall investment regimes are quite friendly to FDI. The Investment Commission of Ministry of Economic Affairs are the main approving authority for any inbound FDI in Taiwan. And as of September 26th, it's actually officially renamed as Department of Investment Review, DIR, still within MOEA, with the enhancement of its administrative scope underway. All the inward FDI are subject to so-called the dual track review. That is one for PRC investors and one for non-PRC investors. For the PRC investor, the main rule is the measure on investment permits for people from of mainland area, and for all the catch-all of all other foreign investments is governed by the statute of investment by foreign national, so-called CFIN. All the foreign investors are subject to a standstill provision. That is, all the proposed investment transaction need to get a pre-approval from the IC before the transaction can be closed. Normally speaking, once you get a pre-approval from the IC, you have 6 months to complete your transactions. If you need more time, one-time extension is possible. Why do you need approval? Very simple, because any in and out foreign transactions into a local Taiwanese bank, they will require to see this pre-approval letter before they okay on the foreign exchange settlement. The IC actually works very closely with other government agencies in Taiwan, and the purpose is to review all the inbound FDI in light of Taiwan's national security, public order, social custom, and public health. But that being said, there's very little statutory guidance on how the national security and public order are being reviewed in each case. All the cases are reviewed case by case and discretionary of the IC. However, that being said, the National Security Bureau is on the IC, and its voice has been weighing in more and more in the recent years given the current development in the cross-strait area. Every month there will be an IC review to review all the major investment into Taiwan.
So as you can see, there's these regimes. There seems to be some that are approval, like CFIUS, Korea, and Taiwan, and others like Europe. Of course, you have a mixture of approval notification. Japan seems to be notification. We're presenting this so that we can give you a comparison of the different countries and the different features as we go along, and that's one of the big comparisons. So I'd like to ask the panelists what type of transactions are covered by each of the regimes: acquisitions, greenfield investments, minority control investments, and minority investments. And again, I'm going to start out with Scott.
In the United States, there's 3 ways that U.S. government has jurisdiction over a foreign direct investment to the United States. In the United States, if there is no jurisdiction of the transaction, the United States government cannot do anything about it, regardless of the national security implications. And so the first step is always a focus on jurisdiction. A little caveat on that statement: if there is very high national security, the U.S. government, from my experience working in the government, tends to push the envelope on what jurisdiction, they'll find jurisdiction as best they can. And so that's sort of a caveat on the statement that if there is no jurisdiction, the U.S. government won't do anything about the transaction. It cannot. In the United States, there's 3 ways the U.S. government can get jurisdiction. One is a controlling transaction, and that's a transaction that has a more than 10% voting stake for the foreign investor. Either has a voting stake and a board seat, so 10% no board seat, a voting stake and a board seat, so significant veto rights and other equity, or other authority or other means to determine, direct, or decide important matters of U.S. business, and that's under the regulations. So that's control. Then there's another jurisdiction based upon, they call it other transactions or sort of minority investments, and that occurs when there's a triggering right from the investment. So if the foreign investor receives a board seat, observer seat, or a nomination right, they have access to material non-public technical information, or they're able to be involved in substantive decision making in the U.S. business's sensitive operations. So they have a triggering right, but they also it's restricted to only three types of U.S. business for this other or minority investment jurisdiction. One is it must be a critical technology business, and that is defined basically upon U.S. export controls. And so if the U.S. business has technology that would be export controlled to the jurisdiction of the foreign investor, that would be is deemed a critical technology U.S. business. Or critical infrastructure, that is a business. There's lots of definitions of what that might be, but it could be a dam, it could be an airport, large critical infrastructure. Or if the U.S. company has millions of records with sensitive personal data, and that's known as a sensitive personal data U.S. business. And these three businesses are collectively commonly referred to as TIE business, T for critical technology, I for critical infrastructure, or sensitive person data for D. In the United States, CFIUS is largely a voluntary process. However, there is a mandatory filing requirement if the foreign investor owns voting shares, acquires a triggering right, which I just mentioned, and that it is a critical technology business, i.e. that the U.S. business would need an export license to export their technology to the foreign investor. And so that's the minority investment. The last one is a real estate authority that came into effect, as well as the minority investment authority under the FIRMA statute, which I referenced earlier. And that basically is where the U.S. business is located. So if the foreign investment goes and buys land or leases land near sensitive military installations, and there's two different types. There's one that's within 1 mile. There's a list that's 1 mile from the U.S. military installation, and then there's a 99 mile or a total of 100 miles from that place. And so if the location of the U.S. The real estate is near a sensitive military installation, they'll have real estate or proximity jurisdiction. And one last point, if there is a mandatory filing requirement and the investor, the U.S. business do not file with CFIUS, there are potential fines and presidential blocks of the transaction, even if it had occurred many years prior.
Thank you, Scott. Lori, Europe, I mean, obviously a lot of countries, as you said, the European Union has an overview, and there's differences between countries, but if you could tell us the types of transactions generally that will fall within the European regimes.
Yes, that's right. This is certainly one area where there's a fair bit of difference across European countries. What we see, generally speaking, though, is that first, acquisition of minority stakes may be sufficient to trigger an FDI filing in many European countries. For example, in Germany, France, or the Netherlands, acquisition of 10% of the voting rights in a target that's active in a sensitive sector triggers a mandatory filing. In some countries, a standalone right to appoint the target's board members can also be sufficient to trigger a filing. That's the case of the Netherlands, for example. Asset acquisitions would also typically trigger a filing in many EU countries, EU member states. That's not the case in the UK, where asset acquisitions do not trigger mandatory filing, but those deals can always be called in later by the government for review. Greenfield investments are generally excluded from the scope of FDI review. There are a few outliers though, for instance, Denmark, Romania, or Slovakia. Those are the main characteristics in Europe.
Thank you, Lori. And G, you indicated that there is that there's a low threshold, which maybe offsets the fact that it's only a notification requirement. But why don't you tell us a little bit about Japan?
Sure. So in Japan, under FEFTA, two types of transactions are covered. First is what's called a specified acquisition or a designated acquisition. That's when a foreign investor acquires from a foreign entity. The more comprehensive transaction that would trigger filing requirements is the inward direct investment, and there's many transactions that are covered under this bucket. The foreign investor acquiring 1% or more voting rights in a listed Japanese company is covered. An acquisition of any share of an unlisted Japanese company is covered. A situation where a foreign investor would be able to consent to material changes to the business purpose of an unlisted Japanese company, regardless of ownership percentage, is covered. Also, consent for material changes to listed target companies where the foreign investor would end up owning a third or more of the voting rights is covered. And then if the foreign investor gets to consent to shareholder meeting proposals, to nominate board members, and if the foreign investor would end up holding 1% or more of the voting rights for a listed Japanese target company, is covered. So all of these situations are covered under FEFTA, Article 27 of FEFTA, and these transactions would trigger the filing requirement if they are investments made in the core designated business sector. So this is kind of a similar scheme across, I think, the US, the EU. These are the sectors that are deemed by the governments as critical relating to critical technologies, semiconductors definitely, some other robotics, pharmaceuticals, dual technology that could be used for met weapons, but we'll discuss that in a later section. So in Japan, in short, to summarize, specified acquisitions and inward direct investments that are in the core designated business sector are triggered.
It's interesting you say that there's a majority that if there's foreign debt that accounts for more than 50% of the companies, that falls under the regime that's different from a lot of other jurisdictions.
Yes.
Yeah.
That's true.
JC.
Sure. In Korea, well, it can be broadly described as if a foreigner is acquiring control over a Korean target that holds certain technology or is a certain type of target, then it would trigger these types of filings. So the key word being control. So to be more specific, under the FIPA, filing would be triggered if the foreigner, as a result of the transaction, will be able to exercise de facto management control over a target, with the target being either the target holding a national core technology, or the target possesses strategic goods or technologies. The target could be a manufacturer of defense materials, or it could be a party to a state contract or national contract that could be deemed as a national secret. Or it could also trigger, there's also a catch-all clause though, where if the foreign transaction as a result would cause any type of national security concerns. Under the ITA, it's similar, but it's triggered only if the foreigner would be acquiring control over a target that possesses national core technology. So under the ITA, it won't be triggered if the target possesses NCT. Now here, control is broadly defined. It could be acquiring 50% or more of equity, even if it's less than 50%. If the foreigner becomes the largest shareholder, or if it controls the board, or if it can control the management, for example, that would all fall under the definition of acquiring control under Korean law.
Thank you, JC. And then, Rose, if you could talk a little bit about Taiwan and the type of transactions that are covered.
Yeah, so for Taiwan, all investments, inbound investments need to be reviewed by IC. There's no particular threshold except in the investment in the public market. That means any greenfield investment need to be reviewed for pre-approval, any merger and acquisition also as well. Some greenfield investment examples, such as establishing a branch office in Taiwan with a local tax ID, or simply like a corporate financing action like raising capitals or reduction in capital in existing private companies incorporated in Taiwan, or simply because of the internal reorganization. All these type of greenfield investment require IC approval. Some other ones relating to M&A, such as cross-border transactions, spin-off, merger, those also require approval by the IC. Even an intercompany loan, for example, of 1 year and longer, those also required and subject to the IC approval. For Taiwan stock-listed public company, there is a threshold for the review. That is, if the foreign investment is acquiring more than 10% in one transaction. But this pretty much generates, a lot of foreign investors. Basically, when they invest in public market in Taiwan, they want to take a certain public company into private. So they usually will make the investment in tranches, but the reporting is necessary. Note that the indirect acquisition of local subsidiaries or like joint venture, why not? Those does not subject to IC approval, so long the capital fundings are sourced domestically and it does not need to receive a capital injection overseas.
So Rose, it sounds like there's some corporate changes and intercompany loans that are covered that some of the other regimes don't have, and also a non-Taiwanese parent transaction is not subject, so you could maybe get around it if they do it offshore. But it sounds to me that that's some of the differences with some of the other regimes. What industries, and I know we've touched upon, what industries in particular respect to technology, such as semiconductors, AI, biotech, are covered by the regimes specifically? Scott, why don't I start again with you?
In the United States, all of the technology types are actually evaluated under sort of a framework, a national security and risk framework that focuses on threat, vulnerability, and the consequence. So what is a threat? The threat is the capability and the intent of the foreign buyer to act in ways that might harm the United States national security. The vulnerability is the U.S. company's target vulnerability that can be exploited because of the foreign transaction. And then the consequence is sort of a so what analysis. What is the negative outcome that could result from the threat and vulnerability being present? In the United States, the President of the United States and the statutes that have been enacted have identified 14 different national security risk factors. I won't mention all of them. I'll just sort of provide a more granular framework. The U.S. government looks at the country of the investor and the U.S. company's sort of technology and what they currently make. In terms of the country, the United States does not have a blacklist, if you will. However, the U.S. government focuses a lot of, or more attention on, China, North Korea, Russia, Iran, but really, I mean, there's not a lot of investment coming in the United States from Russia, North Korea, and Iran. So it's all about China. That's the elephant in the room, if you will. There is actually a whitelist in the United States, CFIUS statute. It's actually referred to as exempted foreign states, and those are investments by the UK, Canadian, Australia, and New Zealand, private investors, but also the government. However, the ability to actually qualify for exempted foreign state investor status is very hard to receive. It's a very hard jurisdictional requirements to meet. So many times, even though an investor might qualify or potentially qualify, will still do a voluntary filing with CFIUS. In terms of the technology, it's a focus on what the U.S. company currently does or what their technology can be used for in the future. The U.S. government is very concerned about investments to the U.S. Defense industrial base. The critical technology areas, which I think will be pretty consistent with other jurisdictions as well, sort of the hot button topics are AI, quantum computing, semiconductor technology, even lower level technology, hypersonics, and biotech. And any technology that is actually subject to U.S. export control. Would make one last note that not only in terms of the country, so maybe a German company doing the investment, the U.S. government is also going to be looking at that company's connections to foreign countries, especially China. So there's a lot of times where CFIUS starts to ask a lot more questions. Say it's a German company, but they have a lot of ties, business ties or investor ties in China. They will likely get more scrutiny for their transaction, even though it is a German, it's a NATO, from a NATO country. Again, the U.S. government is looking beyond to where to that company is where they're doing business.
And Scott mentioned export control. Obviously, that's another form of restriction, but that's beyond the scope. So we're not going to spend a lot of time on the export control, more of the foreign direct investment. And then, Lori, why don't you address the same issue for Europe as to types of technologies that Europe covers?
Sure. So in Europe, we see three main approaches when it comes to national regime. The first one, in a number of countries, screening applies to all sectors, but with lower thresholds for sectors that are considered as sensitive. On the other hand of the spectrum, as a second approach, some countries focus their screening only on the sensitive, on targets active in sensitive sectors. And somewhere in the middle, as a third approach, you have regimes that screen, that requires mandatory notification of investments into targets active in sensitive sectors, but with the power to call in for review investments into any other sector. And the list of sectors considered as sensitive in Europe varies a lot across countries, and what falls within a particular sector also tends to vary significantly. So for instance, many countries have very different definitions of what would fall within AI. As a general trend though, what we see is a general expansion of sectors that are considered as sensitive. And when we look at technology in particular, sectors traditionally considered as sensitive would include semiconductors, robotics, AI, quantum technology, biotech, for example. And I think it's fair to say that the tech sector generally attracts close scrutiny and close attention when it comes to foreign investment. If we look at the numbers in Europe, 40% of the cases that progress to phase 2 review, so a more in-depth stage of review, concern the tech sector.
And thank you, Lori. And sensitive is the key word there, it sounds. But Japan, G, would you address the technologies for Japan?
Yes, sure. So much like the sectors covered in the US and the EU, because we live in an era where the geopolitical situation is the US, its allies versus China, semiconductors are the hot topic and they're on the top of the list. It appears in many countries. So the list of sectors that are in Japan's core designated business sector gets updated. It's getting longer and wider in scope. And I have the latest list from the law firm Nishimura Asahi in 2023. So what's included in this list is critical minerals, storage batteries that are related to electric vehicles, dual-use technologies like magnets used in weapons, industrial robotics, semiconductors and related tools, certainly. And there's been a 2020 amendment that added pharmaceuticals, the manufacture of pharmaceuticals for specific infectious diseases, and manufacture of specifically controlled medical devices, business sectors relating to critical minerals, rare earth, and then related sectors like metal mining, repair and maintenance of software for these devices, etc. And also, FEFTA now added transactions relating to crypto assets as transactions that are covered because and are subject to prior approval because Japan wants to make sure that the economic sanctions against Russia are complied with. And also in 2022, I think aligned with the rest of the world, the CHIPS Act in the US and a similar law in the EU, Japan has enacted what's called the Economic Security Promotion Act to secure its supply chain against supply chain vulnerabilities when it comes to critical materials, synonym which is semiconductors. And so it's very much in line with the global trend of making sure that the supply chain is protected and critical technologies are protected against leakage into China. But what's different from the US when it comes to Japan is that Japan's laws don't specifically expressly name a target like the US executive order does. Because geopolitically, Japan, South Korea, Japan, China are like very close to each other, and Taiwan, which is where TSMC is right under China. So Japan and countries in the Northeast Asia region walk a fine line. We are allies, important allies to the US, and we coordinate, but we do so in a way that's not as express as it's done in the U.S. So that's the list of or the areas that are covered as the core designated business sectors in Japan.
Thank you, G. I'll ask JC the same question about what the technology is covered in Korea.
Right.
You addressed some of it, but if you address
sure.
that a little bit.
Sure. As I think I keep repeating the same term, NCT, National Core Technology, it's actually a specific list of technologies that are considered national core technology. Currently it stands around 75 technologies in 12 different fields, including, again, with other countries such as US and Japan, includes like semiconductors, and display, batteries, biotechnology, aerospace, and nuclear, robotics, etc. What's interesting is that actually Korea also enacted what's called a Special High-Tech Act last year and designated certain technologies as having greater importance in terms of national and economic effects. Those are specifically in fields that Korea has a strong competitive advantage, including semiconductors, displays, and batteries. So there's a special heightened designation that came out last year. Those are all considered national core technologies still. Besides the national core technology, again, which triggers the ITA filing, again, as I said earlier, the FIPA filing can still be triggered even if the target doesn't hold national core technology, but holds what's called strategic goods and technologies. Now, that's more of a broader and less clear term, and the law only provides certain guidelines in terms of the fields and sectors that it covers. So it covers other broader sectors such as electronics, computers, information security, technology, sensors and lasers, and aerospace and nuclear areas. So, those are, even if those certain technologies may not be deemed as national core technology, it still falls under strategic technology and would still be under the purview of the FIPA filing that will trigger foreign investment approval.
And JC, with Korea and its emphasis on technology, those restrictions are even more important.
Yes.
And Rose, how about Taiwan? What type of technologies are dealt with in Taiwan?
Yes, so for Taiwan, subject to Article 7 of the CFIN, the core review is still relies on Taiwan's national security, public order, customs, and public health. Currently there's no list of critical technology, but I'll address that in a bit. But in the following sectors are subject to a higher review scrutiny by the government, that is the financial banking sector, telecommunication, media broadcasting, agriculture, transportation, and energy. Taiwan does maintain a list of accepted domestic industry that's closed off for foreign investment. They call it negative list of investment by overseas Chinese and foreign nationals. That usually covers public utility, power distribution, and some natural gases and some public infrastructure. But that being said, some cases are still reviewed on case-by-case scenarios. For example, French company Air Liquide has a very prominent natural gas business, also for distribution in Taiwan, but that's structured as a joint venture where they own 49%. And just to echo a little bit about South Korea's current regime on national core technology in Taiwan, as of last week, the National Council, Security Council Secretary General made a statement that the government is expecting to issue a list of critical technology by year end of this year to cover semiconductors, aerospace, agriculture, and ICT, which are the more prominent business in Taiwan. And basically, they will get all the recommended list from each responsive department, and the National Science and Technology Commission, semi-independent commission reviewing all the technologies, will make a suggestion and summarize the final list for critical technology for Taiwan. So that will be something in the making.
Thank you, Rose. Scott, you touched on some of the country-specific considerations. So let me ask Lori, because European Union, there's many countries there. What are any of the country-specific considerations or any overriding overall guidelines from the European Union on that?
So in Europe, there is a fundamental principle of European treaties, which is the principle of non-discrimination between third countries, which means that in keeping with that, the national FDI regimes are not targeted at investors coming from specific countries, and they do not apply stricter requirements just because the investor comes from a particular country. Having said that, it's fair to say that countries that have investors from countries that have geopolitical significance for Europe are more likely to trigger in-depth reviews. For example, in Germany, what we see is that oftentimes the deals that go into in-depth review phases tend to involve investors from China or Russia. In addition, with the Russian-Ukrainian conflict, the European Commission has issued guidance directing countries to pay due attention to investments from investors that have links to the Russian or Belarusian government, because those might be more prone to posing national security issues. Having said that, it is too simplistic to say that it's solely the country of the investor that matters, so that weighs into the national security assessment. The target sensitivity, meaning the sector it is involved in, is also particularly important. And I think there are two illustrations to that end. The UK in the past 18 months has imposed remedies in at least 4 deals involving American investors. And if you look at what happened last week, France just blocked a deal that was an acquisition by an American company of a French nuclear part supplier.
So the non-discrimination rule of the European Union has a major impact on that issue. I'm not aware that any of the other jurisdictions have country-specific considerations, JT or Rose, if so. Otherwise, you move on to the next question. So, what constitutes a foreign person that's subject to compliance? Foreign person, some of the laws with similar terminology. Scott, you want to address that and expand on what if there's any comments you already made, just expand on those?
Yes, in the United States CFIUS statute and regulations, a foreign person would be any foreign national, foreign government, or foreign entity, or any entity over which control is either exercised or could be exercised by a foreign national, foreign government, or foreign entity. It is interesting that a foreign company with a U.S. Branch or subsidiary doing interstate commerce, just doing interstate commerce in the United States, would turn that foreign entity into what they call a foreign person. And so CFIUS is concerned about investments by a foreign person into a U.S. business. And so, the U.S. government would get jurisdiction, the first part of the analysis, just solely upon a foreign company selling goods into the United States.
And I'm going to mix the order a little bit. Jeannie, why don't you talk to us a little bit about Japan's definition, if I should say that, of a foreign investor?
Sure. So foreign investor is defined it's much the same as what it is in the U.S. It's basically under FEFTA. Foreign investor is defined as a non-resident or a corporation or other organization established under a foreign law, or a domestic corporation where 50% or more of the voting rights belong to a non-resident, or for a foreign corporation or organization, and also its subsidiaries. So that means a foreign investor would include partnerships where the business would have 50% or more of the total capital is contributed by a foreign entity. And entities in which the majority of directors or representative directors are non-residents. So that's basically, it's not so different from other jurisdictions how a foreign investor is defined under FEFTA in Japan.
And how about Korea, JC?
Sure. It's very similar to U.S. and Japan. So if it's a national person, it would be a foreign national. If it's a foreign corporation, formed under foreign law. There's a third category that actually is pretty unique to Korea. It's something called the International Economic Cooperation Organization. So what it means is it's an organization that is acting on behalf of a foreign government, or if it's an organization dealing with development finance related affairs, or if it's an organization that's acting on behalf of a foreign investment affairs. So there's this third kind of category that would fall under as a foreign investor.
And Rose, how about Taiwan?
For Taiwan, the basic definition of a foreign investor is similar to other jurisdictions. However, I think one key focus is that under the Taiwan regime, they focus on the difference between non-PRC and the rest of the foreign investors. So for a PRC investor, it's anyone with a PRC individual, legal person, organization, and third area company. If a third area company is defined as a PRC investor, if it holds 30% in controlling of that legal entity. So for example, a lot of the investment now are structured as an offshore account. And usually IC will make sure that each layer of the controlling behind it are non-PRC if you're filing as a foreign investor for review. So that's a key differences and to take away for Taiwan. So in general, whenever you make a foreign direct investment in Taiwan, you always have to do a background due diligence on all your investors at every level.
And Lori, unlike the other speakers, you have a number of countries within one umbrella, and you have European Union countries and you have non-European Union countries. So the European situation is a little more complex. You want to address that?
Yes, and foreign in Europe is quite widely defined, meaning that many European member states actually screen foreign direct investment from other EU member states, and sometimes even from investors from their own country, so from local investors. Generally speaking, pretty much every European country screens indirect foreign investment. So let's say a non-EU investor that invests in a European target via an EU-based subsidiary. But the level of scrutiny that can be applied to those indirect investments has become called into question through a recent judgment that essentially says that these indirect investors should be able to benefit from the European freedom of establishment, which means that a European government, a national or member state government, could only block or impose remedies on that type of indirect investment if it poses a fundamental, if it challenges a fundamental interest of society. And that's a higher bar than the standard national security review in many member states. So a key question now is, what are going to be the implications of that ruling? Are we going to see less restrictions ultimately on indirect investment? I think that remains to be seen, and that many member states will be keen on keeping their regimes as they are. And you can imagine that by the time something gets challenged through the courts, many deals will have failed anyway. So the practical implications of that judgment remains to be seen. There is also the ongoing review of the EU FDI screening regulation, and I would expect the European Commission to try to address the consequences of that ruling through the legislative process.
And I think the significance of that definition is that it allows, that it covers transactions where, let's say, a country that is one that would normally have some issues tries to skirt around the rules. And so I think the definition of foreign investor is very similar to many of these countries in that respect. Now the next question is about national security factors. What are the administrative bodies looking at? I think, Scott, you addressed it already for the United States, and whether statutory or regulatory issues. JT, what are some of the factors, if there are any regulatory factors, and so on?
Sure. Korean government actually announced a guideline last year that actually lists a laundry list of factors that they consider in the FIPA and IT filings. Broadly speaking, they relate to, for example, the target companies itself. For example, for instance, if the target company holds any national core technology or strategic goods or technologies, the importance of the target's products and services to the Korean government, to the Korean economy and security, whether there are domestic replacements to the products and services that the target is producing. Those will be the factors that relate to the target company itself. But also they look at other factors for both domestically and globally. For example, they will look at the effect that the foreign investment would have on national security and the economy, as well as the effect it may have on the global investment and trade. So they're probably, I don't think I will go over all the lists, but broadly speaking, those are the kind of factors that the Korean government will look into.
And I'd like to ask the same question of the other panelists. Jihi, some of the factors for Japan.
This is roughly in Japan also. It's roughly similar. I mean, the guideline was posted on the Ministry of Finance's website. Lists those 4 factors that JC mentioned. The possibility of leaking an important technology to national security of Japan. The foreign investors' capital structure, its beneficial ownership structure, what the investor plans to do, what's planned behavior after the investment, and also the track record of compliance to Japan's FEFTA in the past. So I think largely, it really has to do with securing critical technologies, making sure there's no leakage of this that becomes a boomerang to threaten national security of these countries. So those are the factors that Japan considers.
Rose, tell us a little about Taiwan factors.
For Taiwan, obviously the top national security development is the Taiwan Strait tension, and also Taiwan's relationship with the U.S. in the recent years. So that's always the core focus when IC looks at all the inbound investments. And Taiwan currently is developing a list of core technologies. And hopefully that list will come out by year end, and so we can know what are some guidelines also looking at these core technology. But that being said, I think this is mostly going to affect the outbound investment rather than inbound investment, because in general, Taiwan is still welcoming all the foreign investment into Taiwan, and they're just making more cautious moves when particular Taiwanese companies such as TSMC moving outbound. So that is to be paying attention to.
And Lori, can you briefly tell us some of the factors that some of the countries in the European Union are looking at?
So again, we see some different approaches across countries, but I think overall the main factors are very similar to what JC mentioned for Korea and what G discussed for Japan, for example. I would add one important factor for Europe. It is making sure that the deal will not threaten the security when it comes to getting access to critical supplies. And I think this is a particular concern in Europe because of the shortages experienced during the pandemic. Europe doesn't have, for instance, a semiconductor industry locally, and there were also shortages in terms of medical supplies. So I think this is also something the governments look closely at when they review investments.
And Scott, I don't know if you want to expand on that at all. I think you covered most of it. If you want to say a few more words on that? Okay. Oh, okay. And then we're running a little behind, and I want to make sure we have time to talk about outbound investment. So, and ask the panelists to just briefly talk about how difficult and long a process it is for getting approvals. Some of are just notifications, some are pre-approvals, some when you're doing a transaction, you need to take into account the timing factors, particularly in an acquisition or investment. So, Scott, you want to quickly cover that?
Yeah, at a very high level, the United States in recent years, especially in the last maybe 18 months, has taken a much more rigorous, or some people in sort of legal bar might say, a contentious review of foreign investment into the United States. But what that has done is resulted in a longer review time processes, more questions, and more requirements for what are commonly referred to as national security agreements. Those are agreements where the U.S. government has approved the transaction, but they put limitations on the foreign business or foreign investors, so maybe access to U.S. technology or access to the U.S. business. And so that's happening a lot more. But just generally speaking, there's two ways that you do a filing in CFIUS. There's a short form, or it's also referred to as a declaration, that must be filed within 30 days of the closing of the transaction. Just as an example, last year, 58% of the transactions were cleared, or the review and actually approved by CFIUS. In the previous year, that was 73%, so 73% down to 58%. There's a second option to file that's called a joint voluntary notice, and that can either be a 45 or a 90-day time review process. And last year, 56% of the cases actually went to the second 45-day period. But prior to that, in previous years, it was only 47.8%. So again, higher uptake on that. And last year, 18% of all the filings actually went to a national security agreement, whereas the previous year it was only 11.4%. So we're starting to see trends of more strict engagement, more questions, and more national security agreements.
And in the U.S., you have to consider when you're doing a transaction which filing you're going to do, and that's always an important question at the very outset. Laura, you want to talk a little bit about the European Union?
So in Europe, this is probably one of the areas where we see the most differences across countries. Review periods can vary significantly. You will be looking at 30 business days in France, up to 3 months in Spain. In addition, regulators typically have the power to stop the clock, for example, for requests for information. So in cases that involved in-depth review, negotiation of remedies, the process can take at least several months. in the most extreme cases, like the global wafer sale 280 deal in Germany last year, the total review period exceeded 1 year. And timing can also be delayed through the involvement of other member states and the European Commission through the coordination mechanism of the FDI screening regulation. Now, maybe to put things a little bit into context, it remains the case there is only a small number of deals that get blocked. It was about 1% in 2022, 3% of deals were abandoned or withdrawn, and more than 70% of the deals closed without any conditions or remedies.
And I'm sorry to miss the other panels, but if you do very, very shortly, just a very short explanation so that, because we're behind schedule. But Japan, which is a notification process.
Yes, so Japan's process, the timeline is generally 6 months, but if the investor's profile is, generic, it doesn't pose any national security threats, the Bank of Japan receives the filing, gives it to the Ministry of Finance, and the investor can ask for a shortening of the review period to 2 weeks. So that's in place. But if there's a problem, there's something that needs to be investigated by the Ministry of Finance and other ministries, they will take up to 5 months. But generally, the approval, so the clock starts ticking when the filing is made to the Bank of Japan, and this process needs to begin 6 months prior to the proposed closing date set by the investor. So it's generally a 6-month process, and so if there's a problem and the authorities say, okay, this seems to be a problem, they can recommend a change in the investor's plan. The investor has 10 days to accept or reject. If the 10 days passes with no answer, then the Ministry of Finance will order a change to the transaction. So that's Japan's system in a nutshell.
JC, quickly on Korea.
Sure. Korea also has a pretty lengthy process for the FIPA security review process. It's usually 120 days, which could be extended if the regulators find particular concerns with the transaction. In terms of the ITA process, it's about 2 to 3 months. It could also, it could also be longer if there's any particular concerns that the regulators find. So, for investors who are looking to acquire Korean targets or gain control in Korean targets with national core technology or strategic technologies, you have to, kind of build in that type of time between signing and closing to make sure that you have sufficient time to clear these review processes and obtain approvals.
And Rose?
It really varies from case to case for Taiwan, but if it's just a general, very generic inbound greenfield investment, usually takes about 2 to 4 weeks from the date of official submission. And if it's more complex M&A transaction, it will take it up to 3 to 4 months. And this landscape might change based on the changing environment in Taiwan as there's a presidential election coming up next year.
Thank you. And Lori, did you give over the timing factors? Did I ask you already? Lost track. Did I ask you? Okay, so thank you. Apologize for that one. With that, I'd like to talk a little bit about outbound investment, and a couple of these jurisdictions have brought about new outbound investment restrictions. So many of you may be familiar with President Biden's recent executive order, which Scott's going to address right now on outbound FDI.
Yeah, in the United States, in August, 2 months back, President Biden issued an executive order as well as proposed regulations or a notice of proposed regulations. Essentially what that is the U.S. government has asked for comments on the draft regulation. The comment period is ended, and then there'll be another process of actually posting another proposed outbound investment regulations in the next 3 to 4 months. Ultimately, at the end of calendar year 2024, it's expected there will be a outbound investment. We've heard some discussion during the panels here, or you may have heard it on or read it about it in the news. The Biden administration's coined phrase is "big fence, small yard," and that sort of reflects the areas that they're focusing the outbound investment restrictions or notice. So there's a sort of two lists of, there's a prohibition list that the proposed regulations will cover, and that would be for semiconductor and microelectronics. And actually, the regulation actually goes into great detail of what qualifies as a semiconductor and microelectronics. So it's not all semiconductor technologies. Quantum information technologies, again, that term is defined. And then artificial intelligence systems. Under the proposed outbound restrictions, it's a prohibition or a notice. There is no government review like CFIUS. There's an ability to file with the Treasury Department, and they'll do a review. It's either a block or prohibition, or it's a notice. And so in terms of a notice, the proposed regulation suggested that there would be an additional or a longer list for semiconductor and microelectronics technologies and artificial intelligence systems as well. However, there is no plans to do a longer list or a broader list for quantum information technologies. I would note that one of the big debates in the United States over outbound investment is, what Congress tends to take the view that perhaps the small yard and the fence is too small, and then you have like the companies and technology, and they're big business. They tend to say, well, it's actually too big of a yard, or it's too high of a fence. So there's sort of that natural debate. One last point. Right now, there's actually bills in Congress, U.S. Congress, to discuss this, and so the approach that Congress is taking would go into larger or more technologies to include large capacity batteries, dual-use network laser scanning systems, critical minerals, pharmaceutical ingredients, and automobile manufacturing. So much broader than just semiconductors, quantum information technology, and artificial intelligence. So it's really to be determined. We'll know more on what the outbound restrictions and what's covered, and is it a block or is it a notice only? We'll be knowing more about that in the next 12 months.
And that's a hot topic in the U.S. There's some good materials on this in the materials that go into more depth. And Rose, I know Taiwan has an outbound investment.
Can I make one last point? I'm sorry, I apologize. I didn't. I was going kind of fast. The U.S. government's taking the approach that the prohibitions of the notice will only involve China, Macau, and Hong Kong, no other countries. Congress would like to potentially expand that list to be other, Iran, North Korea, Russia. But right now, the president has only focused on China. That's all.
And that's an important point. Thank you, Scott. Rose, would you talk about Taiwan's outbound investment regime?
Certainly. So similar to what Scott just said about the focusing on outbound investment to China, Taiwan in the recent years, particularly in the semiconductor industry, in the ICT industry, they've been making a lot of outbound investment, not just to China, but also to North America's and EU countries. So the government really are, in general, they're very welcoming to and supportive of all these outbound investment made by the Taiwanese companies. But basically, the outbound investment reviews are a 3-track review system. There's one for China, one for Macau and Hong Kong, and for the rest of the world. And for most of the outbound investments, there's a mandatory review required for anything that's above USD 46 million. Anything under, you don't need to file for pre-approval, but you do need to file for notification approval within 6 months after the outbound investment is made. And that being said, for outbound investment, there's no penalty. So like if you fail certain notification or the mandatory filing requirement, but there is one if you for the outbound investment to China. So I want to mention one case that is quite recent. Last year in 2022, Foxconn, a very well-known Apple OEM makers, they made a public announcement in July last year that they want to invest in about 20% stake in a Chinese-backed chip maker company. It's called Xinhua Uni Group. This was not very happy with the Taiwanese government because it did not get the pre-approval from the IC for this outbound investment. By December last year, due to the political change between China and Taiwan, China and US, and also the general changing landscape for the semiconductor, Foxconn declared that they will abandon this deal. So they basically sold all their owning share in the investment vehicle, the domestic investment vehicle in China, holding the 20% stake in Xinhua Uni Group. That being said, in January this year, the IC made a public statement that they will fine Foxconn for the unauthorized deal into China on the semiconductor. Even though the deal did not carry through and the Foxconn abandoned, they still impose a penalty on Foxconn, but the penalty is only less than half of what's the maximum required. The position that the government takes is that because Foxconn brings a lot of business for Taiwan, and also in this case, there's no outward importation of core technology in semiconductor to China, but rather they want to buy the technology from this Chinese chip company. So interestingly, I think Taiwan will develop more and more measures on outbound investment as many of these semiconductors such as TSMC and its suppliers are making major moves outside of Taiwan.
And I don't believe any other jurisdictions, am I correct, have outbound? I know Europe's probably had some pressure, Lori, to adopt stuff. I know we're running over, but just take a couple minutes and tell us if anyone else is, Europe and the other two have anything to say.
So maybe quickly on Europe. Europe does not have mechanism to screen outbound investment, but that debate is gaining political momentum, and the European Commission is expected to release a proposal by the end of this year addressing the risks of outbound investments. We'll have to see how that plays out because there's a lot of political dissension between the member states on the need for that type of regulation. Germany is divided. France is very skeptical about that. But at the same time, Germany is considering a reform of its own FDI regime to include the screening of outbound licensing. So it's wait and see.
And I'm sure the U.S. is talking to its European partners on this issue. JC and G, anything you have to add on that?
I'd like to just add that in Japan, as you mentioned, Paul, when the U.S. speaks with its allies and asks to engage, just like in this year's May 7th G7 summit in Hiroshima, after that, when the U.S. announced strong export controls for advanced node semiconductor equipment, prohibited it from going into China or the use of U.S. semiconductor technology and any export into China. Japan followed with its own measures, putting a stop, because with these semiconductor tools, the Netherlands ASML, Japan's Canon, Nikon and Canon, and the US are the only places you can get these tools, and without them, there's a lot China cannot do. So when something's initiated by the US and the Biden administration engages with its allies, Japan's an important ally and Japan follows. So at this time, there's no comprehensive outbound investment regime in Japan as the US has, but it's in discussion as confirmed with our colleague from another panel yesterday.
Yeah, and Korea doesn't have an outbound regulation just yet, but there's a rigorous export control when it comes to national core technology and other types of technologies. But with U.S., as Scott just mentioned, taking the lead, and other allied countries following suit. Korea, I kind of expect Korea to also follow suit and come up with some type of outbound regulation going forward.
Yeah, the Outbound executive order was in August, so I think you're going to see a lot of development over the next year or so with the other countries. We ran over a little bit. The panelists will be glad to stay up here if you have questions, I know it's past 12 o'clock, but please feel free to ask questions. You can leave, but we'll stay a few minutes for those who have questions. Thank you very much, and I hope you enjoy the rest of the conference.